You get a medical bill in the mail. It looks confusing. You set it aside. Then a few weeks later, you get a letter from a debt collector. And you're thinking, wait, how did this happen so fast? Did the hospital even have to warn me first? Today we're answering that question. And the answer might surprise you depending on where you got your care. Welcome to Know the Law. I'm going to walk you through exactly what hospitals are and are not required to do before they send your bill to collections. I'll cover the difference between nonprofit and for-profit hospitals, what debt collectors must do when they contact you, and the one deadline you absolutely cannot miss. This is information every American adult needs to know before a medical bill turns into a collection nightmare. Not all hospitals play by the same rules. And the distinction that matters most is whether your hospital is a nonprofit or a for-profit facility. Nonprofit hospitals receive special federal tax benefits. In exchange for those benefits, they are required to follow specific rules under the Affordable Care Act. These rules exist to protect patients from being blindsided by collections. So what exactly are those rules? First, a nonprofit hospital must give you at least 2,880 hours from the time you receive your first billing statement before they can take any collection action against you. That is a significant window of time before anything can happen. Second, before that window closes, the nonprofit hospital must also send you a separate written warning. That warning cannot be vague. It has to identify the specific collection actions the hospital plans to take. You deserve to know exactly what is coming, and the law requires them to tell you. That warning must come at least 720 hours before any collection action begins. Third, nonprofit hospitals are required to tell you that financial assistance might be available to you. They must inform you how to apply and include a plain language summary of the application, not legal fine print. Plain language that a regular person can actually understand. These protections are real. They're federal requirements. And if you received care at a nonprofit hospital, you are entitled to all of them. Now here is where it gets uncomfortable. For-profit hospitals have no federal obligation to offer financial assistance. They also have no federal requirement to wait before sending your account to collections. That means a for-profit hospital could send your bill to a debt collector much faster, and there is no federal law stopping them. This is one of the most important things to understand about medical debt in America. The type of hospital you visit can dramatically change your rights. This does not mean you are completely unprotected if you went to a for-profit hospital. Under most state laws, there are additional rules that may apply. Generally, in most states, there are consumer protection statutes that offer some level of coverage. And in some states, the requirements go even further than federal law. Let's say the bill did go to collections. Maybe you missed a notice. Maybe you did not realize the clock was ticking. Either way, you still have rights. And these rights come from a federal law called the Fair Debt Collection Practices Act, also known as the FDCPA. Under federal law, when a debt collector first contacts you, they must send you a validation notice within 120 hours of that first contact. They cannot simply call you up and start demanding payment without giving you this notice. That notice must tell you the amount you owe, identify the name of the creditor, and explain how you can dispute the debt if you believe it is wrong. Every single one of those is required by federal law. Here is the part where a lot of people make a very costly mistake. When you receive that validation notice, you have 720 hours to send a written dispute if you want to challenge the debt. Not a phone call. A written dispute. If you send that written dispute within 720 hours, the debt collector must stop all collection activity until the debt is verified. They cannot keep calling. They cannot take further action. Everything pauses until they prove the debt is valid. But if you miss that window, they can resume collection activity without that pause. The clock is real and it matters. One more thing. Under federal law, collectors cannot call you before 8 in the morning or after 9 at night in your time zone. If a collector is calling you at midnight or at 6 a.m., they're breaking the law. Federal law is your baseline. But in most states, you may have additional protections on top of that. State laws vary significantly when it comes to medical debt. In some states, hospitals are required to wait significantly longer before medical debt can even be reported to credit agencies or before a lawsuit can be filed against you. In at least one state, that waiting period before credit reporting or legal action is as long as 4,320 hours from the initial billing statement. That is a substantial amount of additional breathing room. Under most state laws, there are also rules around statutes of limitations, meaning how long a collector has to sue you over a medical debt. And generally in most states, there are exemptions that protect certain wages and assets from being seized if a judgment is entered against you. Know your state. Federal law is your floor, not your ceiling. Imagine you receive a bill from a nonprofit hospital after a visit to the emergency room. You set it aside because you're not sure if insurance will cover it. Under federal law, that hospital cannot send you to collections until at least 2,880 hours have passed since that first bill. Before they act, they must also send you a written warning at least 720 hours in advance telling you exactly what they plan to do. And they must let you know financial assistance may be available. That is 3 separate layers of protection most people never even know they have. Now you know the law. Hit like, subscribe, and share this with someone who needs to hear it. And drop a comment below with the legal situation you want us to break down next. The law affects every part of your life, and you might as well know how it works. Knowledge is the one thing they cannot take from you. See you in the next episode of Know the Law.